My kids are really suffering behind this because they're young and they don't understand. And my family don't, but they're sticking by me. That's all they can do. It's like I have to do 8.5 years on a 10-year sentence. And it's really, it's really bad. And the judge couldn't, use his discretion or nothing at all to help me.
My name is Terry Amdur. I'm an attorney, and I represented Tonya Drake in the federal case in which she was charged with possession of approximately 230 grams of cocaine base. I was appointed to represent Tonya when she was arraigned on an indictment that was handed up in Los Angeles by a grand jury in 1990. Tonya was charged with possessing the cocaine base and was facing a mandatory minimum sentence of 10 years in jail. It was a particularly disturbing case to me because after I investigated the case, it became clear to me that this was a case that not only did not belong in federal court, but probably should have been resolved in some fashion other than charging her with a felony. She was, at the time I first met her, 27 years old. She had 3 children and was pregnant with her 4th. She had no prior criminal record and no history of drug involvement. She had met an acquaintance at a swap meet and was given $100 to mail a package. She was told by this acquaintance that the package was a birthday present for his brother in Detroit. Needing some money for diapers and food for her children, she agreed to mail the package. She took it to an overnight express office near the airport, paid for the package and kept the change, which amounted to a little less than $48. The personnel at the Airborne Express office were not used to seeing individuals mailing packages. Their business was almost exclusively commercial freight, and they became suspicious, wrote down her driver's license, her car's license plate number, and called the LAPD. The LAPD opened the package, which contained a box of Tide, and inside the box of Tide they found cocaine base, rock cocaine. The police in Los Angeles traced Tonya's license plate number, asked her to come down and speak to them. She came down without a lawyer and talked to them and told them basically she didn't know what was in the package. And they pressured her during their conversation and asked her, well, didn't you suspect it might have been drugs? And she indicated that she didn't know what was in the package, and she didn't know the individual who gave her the package very well, but that he had the reputation of being a high roller and drove fancy cars and wore jewelry. And she didn't know whether he was a drug dealer or not. And based on this quasi-confession, she was arrested and charged in state court with possession of cocaine base. Before the case could proceed very far in the state system, a DEA agent took the case to the U.S. attorney and suggested she be indicted federally. The U.S. attorney agreed, and the state case was dismissed.
She was suddenly plucked out of the state court system by the federal authorities. A federal drug agent filled out the appropriate affidavits and paperwork to have her transferred to the federal system. And at this point in time, she was charged with the federal crime.
And they asked me, did I deliver a package at Airborne Express? And I go, yeah, I delivered. And they tell me that it was drugs in it, and I told them I did not know. The guy told me, that it was for his brother's birthday, and I wasn't aware that it was drugs in it. And they asked me to tell them about the guy and what I knew, and I did. And they asked me, well, what kind of car did he drive and stuff. And I told them that he, drive the black truck, and they was like, well, that's the kind of car that you always see him in. And I said, no, I've seen him in, another car before. So they twisted that and said that he drove all kind of fancy cars, and that I said that he might have been a drug dealer, but I never said that. I never knew. He told me it was for his brother's birthday.
So were you arrested right then and charged?
So yeah, they told my sister they wanted to talk to me, but they arrested me. And I stayed there pregnant in a holding tank, handcuffed behind my back, which was hurting. And I had to bam, bam, kick on the door for them to come and get the sergeant to take the handcuffs, to put them in front of me. And they took me to Silver Brand. So I spent the night at Silver Brand, and my oldest brother came and helped me out the next day.
Okay.
So therefore I went home, and they harassed me, called me, you know, and I kept telling them, look, I'm a pregnant woman. When you want, they kept saying they can help me with my case. And, you know, come to the police station. I told them whatever they wanted to talk to me, they would talk to me my court day, that I was not going to let them get me upset. You know, I had smaller kids, I was already upset, so I wouldn't let them do it.
So what happened at the court?
So I went to court, Compton Court. I went to Compton Court, State Court, me and my family, my sisters and brothers, and...
No, wait a second. Is this were you charged by the state?
Yeah, it was state.
Or it wasn't a federal?
It was not federal, it was state. And we went to state court, and as we got off the elevator, me and my family, they were sitting there, and they said, we hate to tell you this, Mrs. Drake, but we're gonna take you downtown to federal court and introduce the guy who was there. And as we were driving and stuff, they were talking about this is a suspect van, because my brother them was in my van that I drive, that my mother had brought me, that I had delivered the package and my kids was in. So it was like, this is a suspect van or whatever. And I heard just them talking that the reason why, I figured the reason why they kept calling me to come earlier, because the guy, that federal agent friend, he was off of work that day. So while they was telling me they could help me with my case, they really wanted to arrest me a day that he was on, so he wouldn't have to take off, you know, come on his off day to arrest me.
So then you were charged by the federal?
By federal.
Yeah.
And
The result was where she was facing at most 3 to 4 years in jail in state court, and more likely a disposition which would have allowed her to plead guilty to a lesser charge and receive a probationary sentence, or at most 6 months in custody. She now faced a mandatory 10-year sentence and a possible life imprisonment. I was greatly disturbed by this, and I did go to the United States Attorney at the time and suggested that they reconsider this case, whether or not they felt that they really wanted to put this young woman in jail for 10 years. As I indicated, she had no record. She had no involvement with drugs. At the time of her arrest, they searched her apartment and found no indication that she was either using drugs or had been in the business of distributing drugs. The U.S. attorneys told me basically they felt that she belonged in federal court, and by inference that she belonged in jail for 10 years.
The irony of this situation is that had she remained in the state court, she at most could have been sentenced to 3 to 5 years on the same kind of drug charge. Tonya has absolutely no criminal record, has never been arrested before, to anybody's knowledge has no criminal or narcotic contacts, and in fact an evaluation by her lawyer in the federal court of similar cases in the state court, similar in that they were major crack arrests, but dissimilar in that they involved career criminals. This study resulted in the realization that the individuals that stayed in the state court, who were hardened criminals, had arrest records, received 3 years, 18 months, 1 year in a county jail, and even probation. Whereas had they gone to the federal court system, they would have received 360 months incarceration. They would have received life imprisonment depending on their particular crime. They all would have received substantially more, but they, unlike Tonya, were not taken out of the state system and placed into the federal system. Frankly, no one really has the answer as to why Tonya was singled out.
In my investigation of a number of cases that were filed in the state court, a great number of them, especially in cases where the defendants had no prior record, were resolved by a plea bargain in which a defendant would plead guilty to possession of a lesser amount, a misdemeanor possession. And normally those cases were disposed of with probationary sentences, in some cases 6 months in custody as a condition of probation. But in no case would she have been facing more than 3 years in state court. And a 3-year sentence in state court, with the liberal good time allowances that were available in state court, she couldn't have served or wouldn't have served more than 1.5 years. On her federal sentence, she's going to serve 8.5 years.
they got on the stand, witness stand, and they said, you know, their little saying about how I came, and the guy said how I came walking in, and he had me fill out the air bill, and I paid, and I left.
So you were convicted? There was a jury there?
There was a jury there, and they found me guilty.
And subsequently you went for sentencing?
I went for sentencing and was sentenced to, well, the judge was very angry over the, Judge Gadboy, he was very angry over the decision. He said he did not want me to, he never want to sentence me to this. He felt like he believed me how I came in contact with the drugs, that I was no drug dealer or had nothing involvement with any drugs, and he wished he hadn't sentenced me, couldn't have, you know, had a downward departure or anything that he could do to help me that he would have done, that I would have been home with my kids.
But he had no choice.
He had no choice in this.
So he sentenced you to how long?
121 months.
She went to trial, she told the truth. The judge at the time of sentencing stated that he believed her, stated that she did not belong in prison, but also stated that his hands were tied, that he had no way of sentencing her to what he felt was an appropriate sentence of whatever jail time, far less jail time than he was forced to sentence her to, and said he had no choice, and that he had to sentence her to the 10 years mandatory minimum sentence.
Judge Gadboy, he was the trial judge and the judge who sentenced her.
And I gather that he was not pleased about having sent her away for 10 years.
No, none of the judges are pleased with the kind of sentences they're forced to hand down under the mandatory sentencing guidelines.
The legislature will impose mandatory sentences, or what we call determinative sentencing laws, so that the judge's discretion in sentencing is severely restricted. That's true with mandatory minimum sentences in the federal system, where we have very little discretion, if any. Indeed, we cannot go below a mandatory minimum statutory sentence unless a young prosecutor makes a motion to us to do so, and usually that prosecutor would do that if, in his or her estimation, there's been quote-unquote substantial assistance. And once the prosecutor makes that motion, then the court has the authority to go below the mandatory minimum. In other words, I had more authority 30-some years ago as an assistant United States attorney in terms of being able to deal with mandatory minimums than I do now as a lifetime judge who is in a position to try to safeguard society, at the same time as hoping to do something about the individual appearing before me for sentencing. So I've been severely restricted. More nearly than not, we see the use of mandatory minimums in drug cases and the so-called war on drugs. Given a certain amount of drugs, whether it be cocaine or heroin or the worst example, I suppose, is crack cocaine, and crack is merely another form of cocaine itself. The cocaine begins in its powdered form, can be made into this crack form, and as expert chemists tell us, can then be put back into the powder form again. But the Congress has made a determination, I think wrongly, but nevertheless it has made a determination that crack cocaine is more of a serious danger to society than is regular cocaine. And of course, as I try to emphasize over and over again, we couldn't have crack cocaine if we didn't have the powder cocaine to begin with. And the powder cocaine doesn't come from these minority communities where you find the crack cocaine, but the cocaine is cut up, cracked down in these minority communities because it's cheaper in that form. And you find it in the poorest communities, basically black and brown. It takes 100 times as much of the powder cocaine to get the same sentence as you would get for crack cocaine.
Blacks are, in this district, the Central District of California, are the only people charged with cocaine-based offenses. I didn't personally do the investigation, but I understand that there has been a review of all the cases in this district since the law involving cocaine base was enacted back in, I believe, 1984, and every defendant charged in the United States District Court in the Central District has been black. And that's particularly important because the penalties for cocaine base are 100 times greater than the penalties for cocaine powder. And the result is that blacks are being uniformly imprisoned for much longer periods of time than whites are. The most recent statistics I saw were that 91% of the people in federal prison nationwide for cocaine-based convictions are minorities, whereas the majority of defendants in federal prison for possession of cocaine powder are white, and the penalties for cocaine powder are, as I indicated, 100 times less than for cocaine base.
There's another argument going on in the system now that this distinction is without realistic reason. This distinction is unfair in terms of giving the benefit to one defendant with powder cocaine versus another defendant with crack cocaine, and that it makes no sense that the person with crack cocaine should receive a harsher penalty.
At the sentencing, we had argued to the judge that he should give Tonya less than the mandatory minimum 10-year sentence that the statute prescribed. Under the drug statutes for which he was convicted, an individual who possesses 50 grams or more of cocaine base or rock cocaine is required to be sentenced to a mandatory minimum sentence of 10 years in jail. In Tonya's case, she possessed 232 grams. And under the law, the probation officer recommended that she receive the 10-year sentence because the probation officer felt there was no basis for the judge to go below the 10-year sentence. He indicated that he would like to go below the 10-year sentence, but he didn't see how he had the legal authority because the statute compelled that he impose the minimum sentence of 10 years in the case. I filed a motion with the judge suggesting to him that the government remove the case from state court, where it was originally filed, to federal court solely to increase the sentence that she was going to receive, that there was no federal involvement in the case, that it was investigated and prosecuted entirely by state and county officials, and that to bring the case to federal court solely to increase the sentence was arbitrary and unreasonable in her case, and that he should use that as a circumstance upon which to recommend a sentence of less than 10 years. Judge Gadboy was sympathetic and indicated that he would like to give her a sentence less than 10 years, but felt compelled under the statute to impose the 10-year sentence. He left her out on bail pending appeal and indicated that if I could convince the Court of Appeals that he had the power under the facts of this case to give her a sentence less than 10 years, he would be more than willing to do so. However, we were unable to get either the Court of Appeals or the Supreme Court to give us a hearing on that issue, and the sentence of 10 years stood.
He wasn't a personal friend of mine. Like I said, I met him in a club, had seen him a lot of times on the street. We always spoke when we was in club. He bought me drinks. We danced, you know, and...
But did you suspect anything when...
No, he told me it was for his brother's birthday, and that's what I went on. He told me he was going to pay me, and at that time, that's what I had, you know, went on, that this what was in the package. It was already packaged and was a present for his brother's birthday.
So you're saying that 4 days before you were arrested, you heard that...
4 days before I was arrested, yeah.
You heard that this man had been...
that he had been killed.
One of the other ironic aspects of the federal mandatory minimum sentencing guidelines is that there is a way to get around them. The way to get around them is to supply incriminating information about other defendants, either in the same case or in other criminal cases. And what that does is that allows people facing these serious charges in the federal system to basically inform on other people, to cooperate with the government, and therefore have the government agree to a more lenient sentence. Whereas someone like Tonya, who has no criminal background, who was caught up in this set of circumstances, is unable to provide such information because she doesn't know anybody in that world. She doesn't have any drug activities or criminal activities going. And therefore, we have a situation where so to speak, the pure individual who is caught up in a circumstance that leads to this has no way out, and a career criminal who is busy out there involved or at least knowing of other crimes has a way out.
only the government has the power to recommend to a judge that he depart below a mandatory sentence, or in fact that he depart below any guideline sentence based on a defendant's cooperation, either in cooperating against other defendants in the same case or assisting in making a case against somebody who at that point has not yet been charged.
The major offenders, those who are most responsible for bringing the drugs into the country, the ones that you would think that the Congress would want to give these stiff sentences to, but instead, as I have seen, they're the ones who walk away by providing those magic words, quote unquote, substantial assistance. The people at the very bottom, the ones that we commonly call mules, are the ones who have little, if any, information that they can provide, so they don't have the substantial assistance. They then can't take advantage of the prosecutor's largesse and then seeking a downward departure from a mandatory minimum from a federal judge.
To the best of our information, because he was a mere acquaintance of Tonya that she had met, according to her, in nightclubs, and she had seen around the neighborhood. She really didn't know how to get a hold of him, but when she or her family tried to get a hold of him, the best their information was that he had been killed in some drug activity and he was dead, and therefore her only way of explaining her very small role in this situation was lost.
It's a lot of people here that I've talked to who have the same cases that I have, you know, similar first-time offenders, never been in jail before, minor participant in any drug or conspiracy, you know, maybe just knew a person or lived with a person, or telephone conversation that's in here under the.
You're basically having more and more first offenders in jail and more career criminals released early because the jails can only hold so many. There's to say that this is what's good for society ignores the facts. The facts are that many people who obviously do not have a good record for purposes of being released are now being released to make beds available for the first-time offender who has no violence like Tonya in their records, who has no previous criminal activity like Tonya in their records, and these are the people who are becoming more and more the majority of the jail systems, whereas the career criminals are getting out more and more, and it seems to be going against the very logic of incarceration, and that is to protect society. How do we protect society when we have all these nonviolent people incarcerated in lieu and in place of the violent career criminals who are being released to give up their beds?
We find that a lot of these people who are being locked up for these 5, 10, 20, 40, and lifetime sentences are not the violent offenders in society. And meanwhile, there are people who are walking away on the state side who've committed murders, who have maimed individuals, who are constant threats to society, and yet we're told that there's not enough space for them. Again, I want to try to make it clear that those of us who are opposed to mandatory minimums for first-time offenders are not soft on crime. If anything, we want to see the violent criminals put away for the most amount of time. And sometimes it seems to me it ought to be life without the possibility of parole. And that isn't what's happening. And meanwhile, we're spending up to $35,000 a year to maintain a lot of these nonviolent people in prison, and we don't have enough prison space for the violent criminals, the ones who ought to be locked up no matter what the cost. And unless we can talk to our elected officials about this, because they're the ones who make the laws, and as I suggest to you, we do this in cycles, and at times of elections, whether it be mid-year elections or the four-year elections, whatever, whether it be national, whether it be at the state level, or whether it be at the county or city levels, we need to let these people know that we understand that our money is being thrown down a dark hole, that we are getting no results from it, that our society, our communities are not any safer than they were before they went off on this re-election tangent.
The irony to me of the case was that this was a young woman with 3 children. The U.S. attorney at the time was a woman with children. The 3 Court of Appeals judges who heard the case were all women. I presume some or all of them had children. yet none of them showed any great concern for her. The United States Attorney refused to reconsider the charge, refused to consider sending it back to state court, and the three-judge Court of Appeals panel wouldn't even give us the courtesy of arguing the case before they went open court.
What's motivating this kind of an attitude?
Well, I can't read minds, and I don't know. I suppose the idea is that if you put enough people in jail, that the word will get out on the streets, and people will thereby be deterred from committing crimes such as dealing in cocaine. But you clearly send the wrong message when you send a person like Tonya Drake to jail for 10 years when there are much more serious criminals running around loose who are routinely handled in a much more lenient manner, receive much lighter sentences, are out on the street in a much shorter period of time. I think it clearly sends the wrong message when you make an example of Tonya Drake. That is not the message that I think should be conveyed to the community. The legal system does not do itself a great service by making an example of a 27-year-old woman with 4 children.
And my kids is really suffering behind this because they're young and they don't understand. And my family don't, but they're sticking by me. That's all they can do. It's like I have to do 8.5 years on a 10-year sentence. And it's, you know, it's really bad. And the judge couldn't, you know, use his discretion or nothing at all to help me.
Say hi to your mama. Say hi to her.
Mom, this one is asleep. We're probably dreaming about you. So
Wave about your mama. You can wave at her. Say hi, mama. She gonna see you. Say hi,
take
mama.
care of yourself, and hopefully this ordeal will be over with soon.
Hi, Mom.